I will call this meeting to order of the Senate Judiciary Committee. Would the esteemed secretary please take the roll?
Senator Cannizzaro.
She will be here shortly. Please mark her present when she arrives.
Senator Harris.
Here.
Senator Orenshaw.
Here.
Senator Settlemyre.
He is on his way. Please mark him present when he arrives.
Senator Hansen. He's missing today, I think. Senator Pickard. Chair Shriver.
I am here. Thank you. And we have a couple of bills on the agenda today. We are going to take them in an order that may look random, but it is designed to accommodate the schedules of our hardworking lawmakers, agency staff, and other participants in this hearing or in these hearings. And so I will start today with AB 157, and I will now open the hearing.
Good afternoon, Chair Scheibel and members of the committee. For the record, I am Assemblywoman Danielle Monroe Moreno. I represent Assembly District 1, which is primarily in the city of North Las Vegas. I am here today to present for your consideration Assembly Bill 157, which addresses a serious problem that has recently gained national recognition: the discriminatory use of false 911 emergency calls against certain groups, especially against communities of color. This bill represents an effort to call attention to the problem and provide a legal remedy to victims of discriminatory practices. As a point out in the whereases clause beginning on page 2 of the bill, recent national news stories in 2020 drew the attention of state legislatures across the nation to false 911 calls, when the intent was to harass a person or a group of persons because of their inherent characteristics, including their race, gender, nationality, religion, disability, or sexual orientation. Many specific occurrences went viral on social media, and incidents like the bird watcher in Central Park asking the woman to put her dog on a leash were recorded and gained national attention during a weekly news cycle. As is so often the case, this media exposure led to more and more of these types of cases coming to light. I think we can all agree that at the very least, these occurrences represent a misuse of our law enforcement personnel, wasting their time and taxpayers' resources. More importantly, they cause serious mental and even at times physical harm to the victims of such incidents. The sense of harm extends to the community as a whole, to communities of color, and to our judicial and law enforcement communities as well. The social harm of such incidents splits the fabric of our society and contributes to the distrust of government in general and our law enforcement specifically. We need to find ways to rebuild trust, and I believe that AB 157 can be a part of that effort. I would like to note that similar bills have already been passed in New York, Oregon, and Washington. In fact, the sponsor of the Oregon bill, a fellow legislator, encountered the very type of incident this bill will address. Oregon State Representative Janelle Bynum, who is Black, walks her district like most of us walk ours, going door to door to talk to voters. She takes notes about constituents' concerns on her phone as she goes along, as many of us do. 2 years ago, a resident of a mostly white neighborhood in her district found her campaigning so suspicious that she called the cops. I think you can see why we need to address this matter. Madam Chair, at this point, I'd like to review the highlights of the bill as it was amended in the Assembly. AB 157 aims to address these deliberate, false, and discriminatory reports by providing the victims of such reports with a specific and effective targeted remedy. The form of this relief is in the ability to bring a civil action for damages against the persons making the reports. In Section 1 of the bill, beginning on page 3, defines the circumstances under which a person can bring such an action with regard to the person making the false report without reasonable cause. The report must knowingly cause a peace officer to arrive to a location and contact the person being discriminated against. Subsection 1 identifies the discriminatory conduct and defines the specific type of harm and outcomes that would allow for civil action under the bill. Subsection 2 lists the potential forms of damages along with the costs and fees that may be recovered by the person prevailing in the suit. The remaining sections authorizes the action under the bill even if related criminal convictions already exist and provide for other technical matters. I myself spent almost 30 years working in law enforcement as a corrections officer. And I personally saw how sometimes people of communities in our community can try to use the police as their own weapon. And as a law enforcement officer, our time is precious. We're there to serve and protect and to address real crimes being committed in our society, and tying up our police officers' hands on these frivolous, sensical, and criminal cause has to come to an end. I urge the committee to pass AB 157, and with that, Madam Chair, I'll stand for questions.
Thank you so much for your presentation, Assemblywoman. Are there questions from members of the committee? We'll go first to Senator Harris.
Thank you, Chair Scheibel. No question, just a comment. Thank you, Assemblywoman Monroe-Moreno, for bringing this bill. I thought a lot about how to address these types of calls, and I think you've come up with a great solution in a civil remedy, so thank you.
Any other questions from members of the committee? All right, I would also like to express my appreciation. I don't have a question, but I think this is a fantastic idea, and I look forward to continuing to work through the bill. So with that, we will move to testimony. We will start with testimony in support of AB 157, and it looks like we have at least one person present in the room to give testimony, so we will start in the room, and each testifier, as always, will get 2 minutes.
Good afternoon, Chair Scheibel and members of the Senate Judiciary. It is a pleasure to be here in person. My name is Kendra Birchie with the Washoe County Public Defender's Office. We just want to put our support on the record. We believe that this is an important bill that will help aid our community members to feel safer and also to ensure that our community is not weaponizing the police. So we really appreciate this bill and urge your support. Thank you.
Thank you. Is there anybody else here in person? There is someone else to give support testimony in person.
Thank you, Madam Chair and members of the committee. My name is Steve Gramis. I'm the president of the Las Vegas Police Protective Association. I represent over 3,500 commissioned officers down in Southern Nevada. I came here today to just listen to bills. This was one that I did read about, and as you dig into the bill, it's very clear that it actually helps us as officers to quell false calls for us to respond. It's no secret that if somebody calls the police and they make a claim, we have to respond. However, most times when we get there and we find that they are false claims, it aggravates us as much as it does the person that we're called to investigate. So I think looking at this bill, I thank Ms. Monroe-Moreno, because I do think this is going to help us to not have to respond to calls, because inherently the people that we're responding to will probably take issue with us more so than the person that called us. And maybe this will help us in the future not have to respond to things like this. So we at the PPA support this bill. Thank you.
Thank you very much. It looks like we don't have anybody else to give comments in person, or sorry, to give support testimony in person, so we will move to support testimony on the phone. and this is on AB 157.
Thank you so much, Chair Scheibel. To testify in support on Assembly Bill 157, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 157, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 611, please slowly state and spell your name for the record. You'll have 2 minutes to speak. It may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. This is John Pirro from the Clark County Public Defender's Office testifying in support. We'd like to thank Assemblywoman Monroe Moreno for bringing this bill forward. There's most certainly a need for action to combat frivolous and malicious complaints to the police. And we think this is a great bill and urge the committee support. Thank you.
Thank you, caller. Caller with the last 3 digits, 087, please slowly state and spell your name for the record. You'll have 2 minutes to speak. It may begin.
Good afternoon, Chair Scheibel and members of the committee. My name is Jared Luke, Jaredluke. I'm the Government Affairs Director for the City of North Las Vegas. I want to thank Assemblywoman Monroe Moreno for bringing this bill forward and just throw our support behind AB 157 and state simply that we denounce all harassment, especially harassment that comes from a racial nature. It has no place in society today, and I think this bill is a good step in the right direction, opens up conversation, and hopefully will evolve into other programs that protect those that need protection. Thank you for your time.
Thank you, caller. Caller with the last 3 digits, 130. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair and members of the committee. For the record, my name is Christine Saunders. That's ChristineSaunders, and I'm the Policy Director with the Progressive Leadership Alliance of Nevada, here in support of Assembly Bill 157. We have seen through recent viral videos and for many decades, including cases like Emmett Till, where false accusations can lead to great harm and even death, especially for people of color. This bill creates a process of accountability for people who use the police with ill intentions. We ask for your support. Thank you.
Thank you, caller. Caller with the last 3 digits, 035. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the committee. My name is Quentin Savoy, Quentin, last name Sabwoir. I'm the Deputy Director at Make It Work Nevada. We stand in support of Assembly Bill 157 and deeply appreciate Assemblywoman Danielle Monroe Moreno for bringing forth this legislation. I echo many of the sentiments that my colleagues and comrades have already expressed. We're facing a time of racial reckoning where frivolous calls to police on the basis of skin color can no longer be acceptable. Thank you so much for presenting this legislation, and we urge bipartisan support for AB 157.
Thank you, caller. And a brief reminder, if you've recently joined us, we are currently on support testimony for Assembly Bill 157. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. And Chair Scheibel, at this time, there are no more callers to provide support testimony.
All right, then we will move to testimony in opposition to AB 157. I don't see anybody in the room to give opposition testimony, so we will go directly to the phones, please.
Thank you, Chair. To testify in opposition on Assembly Bill 157, please press star 9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 157, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
All right, thank you. We will move to testimony in the neutral position on AB 157. I don't see anybody in the room to give testimony, so we will go directly to the phones, please.
Thank you, Chair. To testify in neutral on Assembly Bill 157, please press star 9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 157, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide neutral testimony.
All right, thank you so much for your help, Mr. Kyle. Thank you, Assemblywoman Monroe Moreno, for your presentation. That concludes the hearing. I will now close the hearing on AB 157. I'm sorry, Senator Settlemyer.
Sorry about that, Madam Chair. Usually we have an opportunity to have the sponsor come back up and ask questions or things of that nature. I agree with the concept of the bill immensely. Matter, I'd like to go actually further. I mean,
So I'm going to pause you 1 second. It sounds like you want to ask a question, so I'm going to invite Assemblywoman Monroe Moreno back to the table, and then go ahead with your question. And the hearing's still open, in case that wasn't clear.
thank you, Chair. I apologize for not walking in late. I had another meeting. And I guess I have to be careful how close I get to the microphone today. In that respect, I was thinking that we ought to take this even further, that even just take it out of the section. If you prevail, if someone takes your constitutional rights, if you prevail in an action against anyone on a constitutional issue, just as you have, I think it's called a USCA 1983 case, if you prevail, you get your attorney fees. Why shouldn't we have a baby USCA 1983 that if you violate the Nevada Constitution, you should get your attorney fees? Just even outside of this, just a generalized concept.
This is Assemblywoman Danielle Monroe Moreno. Senator Settlemyer, I had not thought about that, but I will look into that. Yes, in drafting the bill, I wanted to make sure that the cost for the false reports, for the time and effort from our law enforcement agencies and first responders would be taken care of as well. I think if you hit people in the pocketbook, they think twice about what they do. Our jails are full. I don't need more people in the jails. But that is a concept that I would look into. I had not thought about that.
Thank you.
Thank you.
Thank you, Chair.
Sure, this is Melanie Scheibel for the record. I'm just going to weigh in that there is a clause in Section 1, subsection 2, sub C, that says that the person bringing the civil action may recover costs and reasonable attorney's fees incurred in bringing the action. I'm not sure if you're thinking of something more specific or if that would address your question.
Thank you, Chair. I just concerned that this would only be pertaining to Chapter 41, whereas I think it should be broad-based to all laws.
Understood. I'm going to punt this one to legal because I think that is the law in any civil action regarding a constitutional right, but that is not my area of expertise.
Thank you, Chair Scheibel. Yes, I believe Senator Settlemyer is correct. The federal 1983 action does include a clause for attorney's fees if you prevail. I'm not sure that Nevada has that same provision, and I could further look into it, but off the top of my head, I'm unaware that we currently have that same provision.
All right, then. Sounds like a fun research project. Thank you for bringing it up, Senator Settlemyer. Thank you to Mr. Anthony and Assemblywoman Monroe Moreno for responding. And with that, I will now close the hearing on AB 157. I will now open the hearing on AB 158.
Good afternoon again, Chair Scheibel and committee. For the record, I am Assemblywoman Danielle Monroe Moreno, representing Assembly District 1, and I'm here today to present for your consideration Assembly Bill 158, which addresses the penalties for youth cannabis and alcohol purchases, consumption, and possession.
And I'm going to interrupt you very briefly. I'm so sorry. I meant before you started to let the members of the committee know that an amendment was just posted to Nellis. We also have a couple of hard copies here in the hearing room if you need one. I am guessing that our amazing presenters are going to reference it, so I wanted to make sure that everybody had adequate access.
Thank you so much. I bring this bill to you at the request of a community member and activist who, as I, has seen far too many young people, especially Black and brown youth in our communities, receiving a criminal record long before they even get an opportunity to get their first job. On November 8th, 2016, Nevada residents voted and passed Question 2, making recreational marijuana up to 1 ounce officially legal for persons 21 years or older, and medical marijuana for persons 18 years or older. As a legislative body, we have worked hard to create legislation to reflect the changes in our laws following the passage of Question 2, as it pertains to adults. However, for our youth, our statutes have not changed. Currently, those found in possession of 1 ounce or less of marijuana or possession of alcohol remains a possible criminal misdemeanor offense, which is punishable by imprisonment for not more than 6 months or by a fine of not more than $1,000 or both. It is the bill sponsors and requesters' intent to revise the penalties for these offenses, such that would provide a more graduated penalties targeted to address the conduct while ensuring that we are not interjecting children into the criminal justice system cycle. The language of AB 158, as it was originally introduced, did not exactly meet our original intent. There has been a collective effort, and as the chair mentioned, efforts up until earlier today on amended language. There have been conversations and diligent work between the Public Defender's Office statewide, our district attorney's offices statewide, and community stakeholders who have worked to amend the language to meet the original intent. Joining me here today virtually is Ms. Aisha Goins of Black Joy Consulting to explain the reasons why and the intent of this legislation, and Ms. Kendra Bertsey from the Washoe County Deputy Public Defender, who will walk you through the bill's conceptual amendment that you received. So with your permission, Madam Chair, I will turn the rest of the presentation over to them.
I am happy to do that. We also have Miss Ashley Dotson, I believe.
That is correct.
Okay.
Thank you.
Whatever order you would like to go in.
Thank you, Madam Chair. Thank you, Madam Chair. This is Aisha Goins. And a youth magazine interviewed incarcerated youth. How does it feel to lose your freedom? It hurts more than any kind of punch, slap, anything that was ever done to me. Having my freedom taken away is the worst thing that ever happened to me. It's not the fact that I'm in jail that I'm scared. For a while, I didn't know what was gonna happen to me or when I was gonna get out. I felt the whole world was going on without me, and I was stuck. I have a little sister born after I started running away, and I don't even know her. My family came out twice this year. You get special visits for a half an hour. For the past year, I've seen someone I know from the outside for like an hour. They asked that same youth, what do you think your parents could have done that would have helped? She said, if my mom had just sat me aside and talked to me and asked me what it is that I want, that would have helped. They also asked the young lady, Elizabeth, 18, how do you feel compared to the average teen? She said, I feel totally different, like a different species. I feel older because I've seen so much. On August 5th, in the 31st Special Legislative Session, the Assembly and the Senate unanimously passed SCR 1, a proclamation that declared racism a public health crisis. The first paragraph reads, whereas, as stated by Maya Angelou, prejudice is a burden that confuses the past, threatens the future, and renders the present inaccessible. And whereas systematic racism and the structure of racial discrimination creates generational poverty and perpetuates debilitating economic, educational, and health hardships, and disproportionately affects people of color, causing the single most profound economic and social challenge faced in Nevada. The 2019 Clark County Department of Juvenile Justice Services statistical report states that possession was the #2 most referred offense to the juvenile justice system. This is 3 years after legalization, battery being number one. The report also said that 1,009 youths that had been referred for possession of marijuana, 803 of those youth were Black and Hispanic. The intent of AB 158 is to ensure fairness and equality in the justice system as it relates to possession of alcohol, tobacco, and cannabis for those juveniles and persons under 21, to offer a second chance to those youth that may have just made a bad choice. Today, I urge the Senate to pass this bill for my son and my other community nieces and nephews. That is the end of my presentation.
Thank you, Chair Scheibel and members of the Judiciary Committee. Kendra Birchie with the Washoe County Public Defender's Office for the record. I'll start with the conceptual amendment, and I do appreciate your staff's very hard work with getting it already uploaded on Nellis. Just so everyone aware, it really does not change the bill very much. It's a lot of cleanup language, as well as just complying with what the parties had all agreed to in the Assembly. So I just want to make sure that's clear on the record. The goals with this amendment and this bill is to ensure that our criminal sanctions are proportional to the offense committed and to promote equity in the justice system. So I'll start with Section 1 of this bill, and this is specifically referring to offenses for alcohol with youth aged 18 to 21. So this is not for those under the age of 18, and obviously it's not for those over the age of 21 because it is illegal and not a status offense at that point. So in Section 1, Section 3, and Section 4, it's all the changes are the same. Of what we're doing is just changing the structure for the penalty. For a first offense, the penalty could be attending basically what's a victim impact panel. That's what's outlined in NRS 484C.530. And so it's just basically providing different options for the court to ensure that, we're not over-criminalizing individuals. And then it also provides increased penalties if somebody continues that offense. So for a second offense, then it's not more than 100 hours of counseling or participation in the educational program or other treatment program. Again, that gives the judicial officers more discretion to take a look at that case and see what is really going on to ensure that we're providing the most appropriate penalty. Then if somebody who's between that age of 18 to 21 continues to engage in this conduct, so for a third or subsequent offense, then they shall be punished as provided in NRS 193.150, and that's just the punishment for all misdemeanors. So then again, it just provides the court with the discretion to determine what they see as most appropriate. Then if you look in that subsection 3 in Section 1, this is an extremely important piece of this bill because it allows for automatic sealing when that child or then when that person age 18 to 21 has completed what is necessary for what the judge decided should be the appropriate punishment. That's different than normal misdemeanors where the person would have to petition, but this ensures that the individual has that taken off of their record when they have earned it. In Section 2.2 of the bill, this is where we're getting into those youth under the age of 18. So what's important in that first section is that it brings these punishments or these violations of a marijuana, small amount, or an alcohol offense into a child in need of supervision, a CHINS offense. The reason that is important is because it provides it as a status offense instead of as a delinquent offense. We have then, as you'll see in the punishments, we mirrored this off of other similar status offenses, such as tobacco. The amended changes in that subsection that you'll see in the amendment that was posted really doesn't change much, as I indicated, just make sure that we're encompassing all offenses that are related to alcohol and marijuana. Then in Section 2.2, this is where it lays out how law enforcement and how the court should handle conducting these cases. So again, this is mirrored off of already existing law with tobacco for status offenses. We're indicating that a peace officer, instead of arresting, they're to issue a citation. And then it discusses what they can do if the individual doesn't want to sign the citation. And that's based off of our current laws for traffic violations, where officers then can, how they handle issuing a citation to ensure that the person would come to court. In section 2.6, subsection 2, it describes where there could be a possibility for an individual to be arrested under certain circumstances, laying out specifically where if there is an imminent risk of safety or imminent risk of harm to the child, and the safety of the child will not be ensured by placing the child with an adult relative of the child, a treatment facility, or a shelter, to assist children who run away from their parents or guardians or victims of sex trafficking. The amended language includes in there that it must not be a shelter used for the protection of children under NRS 432B. There is some concern with the district attorney's office that we would, instead of that law enforcement may first be looking at those shelters. So just to be clear on the record, the shelters that we were considering for this, where the children should not be placed, would be places like Child's Haven in Las Vegas, Kids Cottage in Washoe County, and Austin's House in Carson City. In section 2.8, this is where it sets out the framework in section 4, these offenses for youth under the age of 18. In subsection 1, this is what's really important, is that it's describing that this is a CHINS offense, and so it would be handled informally. For a second offense, again, we believe that if somebody continues to commit these offenses, that the punishments should increase. That's where they could be referred to a probation officer and handled by not more than 24 hours of community service. And then for a third offense, that's when the delinquency petition could be filed. What I would just say on the record is it's been very interesting in learning about how this is currently in practice across all of Nevada, where the different jurisdictions are handling these offenses very differently. And so we do believe that it is important to codify that we are treating our kids the same regardless of what jurisdiction they are in. So although there are some jurisdictions where we currently are having lower penalties for these offenses, we do believe that this is appropriate. Thank you.
Just in closing, this is Assemblywoman Danielle Monroe Moreno, Madam Chair and Committee. I thank you for giving us the opportunity to hear our presentation for Assembly Bill 158. I believe collectively we can agree that children are just that. They're children. And we as adults, we have an obligation to meet them where they are. Hold them accountable, yes, for their actions, while giving them all the necessary tools they need to learn from mistakes that they make, and to assist them into becoming healthy, productive, successful adults. And with that, I urge your support for Assembly Bill 158.
Thank you very much. Do we have questions? Senator Orenshaw.
Thank you very much, Chair, and kind of a combination comment and question. Assemblywoman Monroe Moreno, thank you very much for this bill, and I've had the pleasure of serving with you on the interim Committee on Child Welfare and Juvenile Justice. You chaired it in the prior interim, and were the able vice chair this interim, and I thank you for your dedication to children, and I really do. I think this bill will help a lot of kids not get caught up in the system, and possibly just, get the guidance they need without having to either be in court or in a detention facility. One question I have, and I'm not sure if maybe I need to wait for someone later on, but if if let's say a child is on juvenile probation or on youth parole and is found with a small amount of marijuana under this legislation, do you think that would still qualify as a violation of juvenile probation or a violation of youth parole? Or do you think that this might change that if this passes into law?
This is Assemblywoman Danielle Monroe Moreno. I am not an attorney. I don't even play one on TV.
Smart move. There's too many of us around. You made wise decisions.
However, just as a citizen, I would believe if there were conditions of parole or probation, and that was a condition that the child could not use alcohol or marijuana, being caught with the possession of it would be a violation. But I'm not an attorney.
Well, I appreciate your not being an attorney, your answer to the question, and thank you for this legislation.
Other questions? Go ahead, Senator Pickard.
Thank you, Madam Chair. I don't remember if it was Ms. Goins or Ms. Birchie who made a reference, and I may have misheard it, and I hope I did, because I think there was a reference to marijuana having been legalized for those under 21. That's not my understanding.
Kendra Burgee for the record, and just to be clear, if that was stated, that's not the case. It is legalized for those over the age of 21. It is not legal for those under the age of 21, which is why we're bringing forward this bill. And just to be clear on the record, this does not decriminalize the use of marijuana for those under the age of 21. It's just providing for different penalties and punishments.
All right, thank you. I wanted to make sure that I had the right foundation. I'm aware of, at least in Clark County, there is a drug diversion program for youth. That goes up to the age of 18. So it doesn't necessarily, unless they entered before 18, they can continue for a time. This seems to replace that. My understanding of the diversion program, and there's also a drug diversion program for those over the age of 18 in Clark County. This seems to replace it. But if it doesn't replace it, where does that fit in? Because one of the things that I have been taught is that the best time to catch the youth is on their first exposure, their first use, the first time they're caught, essentially, right? And if we can't get them into a diversion program and ultimately into some kind of treatment program, but we instead allow them to continue to use, it is far less likely to take hold. They are far more likely to continue and then end up in the adult justice system. So how does this intersect with the diversion programs?
Assemblywoman Danielle Monroe Moreno, you and I were both children at one time, and we made mistakes. We're also parents. And not every child that lights a joint or takes a drink is going to be addicted to a substance, become addicted to substance. Sometimes what that child needs is to have their mother interject. Had I got in trouble as a child and you told me I'm going to call the police or call your mom, I would have said, please don't call my mom, call the police. And sometimes that's what children need, is that guidance from the parent or the grandparent or the aunt or the uncle, instead of putting them right into that diversion program. Because putting a child in that diversion program is truly that first step into the system. And not every child needs to be in that system. And yes, if we catch them early, we can stop behavior, but stopping that behavior might be the conversation with mom, letting mom and dad know what's happened. But if we get them that second time, that third time, that's where I see that diversion program coming in, because we've utilized that first and second.
All right, so can you point me, what I hear you saying is that this would be I hate to use the term strike because that is horribly overused, but we've got this progressive system, first offense, second offense, and I'm in section 1, sub 3. No, it's sub 4. Is that right? Oh, no, I'm sorry, it's sub 2. For first offense, 24 hours of community service. Second offense, 100 hours of counseling in an educational program or support group. This is why it sounds like we're replacing the diversion courts, because that's kind of what the diversion court's doing. And then third, as provided in 193-150. And so it seems to bypass the diversion program.
If I may, Kendra Birchie for the record. So first I want to make sure we're talking about the same section where we are specifically looking at in section 1, those who are aged 18 to 21. And you are correct for the first and second offense. It would indicate that a person would not be going to that diversionary treatment program because they would be participating in counseling or other options, where according to studies, it shows that if you interject someone into the criminal system in terms of giving them too many different requirements and other things in supervision, then you're actually more likely to increase their risk of recidivism. So this is what we're hoping will take that into consideration, where for minor offense, for that first one, where there's no other criminal activity involved, that you're just treating that and giving them, that carrot and the stick approach of you're saying, hey, this is the punishment. You can't do this. You're not legal to be drinking or using marijuana. You need to correct this, and you're going to be, because the way that this is an enhanceable offense, you're going to have the judge significantly scold that person on the record and have to say, here are all the ways that if you continue down this path, your life will be, what will happen to you. So, and I would just say, for your information, unfortunately, some of those diversionary programs don't exist outside in other jurisdictions, especially in some of the rural jurisdictions. And if I may, to your first point earlier regarding for the juveniles before the age of 18, unfortunately, we don't have those, I believe you're talking about the Harbor program in Clark County, where we don't have that in Washoe County or the rural jurisdictions. So that was something that we had considered to make sure that we're not completely replacing that program, where for the subsequent offenses, yes, that could be utilized. But we did not want that in statute because not every jurisdiction has that program. And so we wanted to make sure that we provided outcomes that will work across the state regardless of where that child's located.
Well, and I really do appreciate you mentioning that, because I have a bill that will put the harbor in every county in Nevada. We'll see if it gets a hearing. But at the end of the day, I would love to see those studies, because the studies that I'm aware of, it's no secret, my wife has been the hearing master and now a district court judge, and she has run the juvenile drug court in Clark County for many years. And so I see these studies come across from various organizations that suggest kind of the opposite. That at least what I'm recalling is, and I may have this wrong because I'm not the one who was studying these studies to implement them, but it's my understanding that the children, once they've been picked up, they've had a petition filed, these are children who don't have the kind of mothers that you and I had that made sure that we didn't get into this stuff. And so they end up with some in need of more than just a good solid scolding, knowing that there would be worse. Because I'm in the same boat. My mom would not have didn't tolerate this sort of thing from us. But those aren't the kids that generally find themselves in the juvenile justice program. I mean, they do, but at the end of the day, we're talking about a more global approach. And so I would love to see the studies that show that early intervention is not effective, that it does actually incentivize or make it worse for them. But at the end of the day, I guess what I still don't understand is we go through first and second tier, so diversion court is after the third tier?
Kendra Birchie for the record. And first, I want to make sure that my comments were clear. I was not saying that there's no intervention is appropriate to then stop that behavior. What I'm saying is the including too much requirements and supervision, that's what the studies have shown will then actually lead to a potential increase in recidivism. And I'm not sure, so if you could clarify for your question as to if it's just when the diversionary, I'm just not sure I understand correctly.
Yeah, well, it's because I don't understand if this isn't replacing the diversionary program, I don't see where that comes in, because as I understand it, 193-150 is post-diversion. And so it seems as, and again, I'm looking specifically at Section 1, but Section 2 has similar language. If we're going straight from 100 hours of counseling to juvenile or a delinquency matter under 193-150, then this is why I was under the impression we've skipped the diversion. And because we had to do a statutory authorization for the diversion, I don't want to undo that accidentally.
And I'm going to interject here because I have information that you don't have, which is that Bridget Duffy is also on the phone. And so I just wanted to let you guys know so that you can decide if you want to continue to engage in answering the senator's questions, or if you would like to kick that over to Ms. Duffy. I know that she would also be happy to weigh in here.
Kendra Birchie for the record. I'm happy to answer that, and because we are dealing still with the 18 to 20-year-old section. And so, yes, you are correct. For the first and second offense, they would not be looking at a diversionary program. For the third or subsequent, then that is where the diversionary program could be utilized.
Does that conclude questions?
Just one other question, and that has to do with is there a difference in treatment's wrong. Do we apply this differently for alcohol and marijuana use, or is it any controlled substance?
Kendra Birchie for the record. This bill is specifically for alcohol and marijuana. So if somebody's using a controlled substance that is not one of those, this would not apply, and we're using those diversionary programs, and their punishment for those 18 and older would be according to the other statutes for misdemeanors.
All right. And I suppose when Ms. Duffy gets on, I'd like to ask the question of her is, do we need language ultimately to preserve the authorization for diversionary programs? So thank you, Madam Chair.
All right. I think we have a question from Senator Settlemyre. Go ahead.
Thank you, Chair. I appreciate that. I was just kind of curious. I know that within alcohol, sometimes there's a different level of offense based upon the level of alcohol that's detected in your body. I was wondering if that would be consistent, because sometimes, if you're just slightly over, but if you ended up being in the hospital, it may require actually having to go through a whole different system of detox whereas marijuana doesn't necessarily have the same addiction level that sometimes alcohol can. So I was just kind of curious about that. I'm sorry if I'm taking us into the weeds. I don't mean to.
Kendra Birchie for the record. For someone who is just possessing alcohol over the age of 18, there's not a difference in the treatment if they are driving while under the influence of alcohol or marijuana. Then there is a difference in the penalties with how we handle those offenses. But to my knowledge, there isn't a difference.
I appreciate that. I thought there was a difference if you were found at a party and you were underage drinking, that I thought there was also a level attached to that the amount of diversion you went to potentially changed based upon how intoxicated you were. If you were found to be per se incapacitated, it brought a different level of offense. If it does not, I apologize.
Kendra Birchie for the record. To my knowledge, it does not. I would just note it regarding the juvenile offenses. That's where we can take into consideration of whether or not that person could be remaining at liberty and just receive a citation, or whether or not that then leads to that imminent risk of harm where the law enforcement does need to take appropriate measures.
Thank you. I appreciate that. Thank you, Chair.
Of course. And I think Senator Orenshaw had another comment or question.
Thank you very much, Chair. And Mike, kind of in response to Senator Pickard's question, as I read Section 2.8, I read it that, if a child does have, let's say, a first offense involving alcohol or marijuana, they wouldn't be in the juvenile delinquency system. They'd be a child in need of supervision, referred to a probation officer for informal supervision. And there, the probation officer, as I understand this, could still recommend maybe drug counseling or a class about the dangers of drug and alcohol abuse. I see the same thing with the second offense. And then if there is that third offense involving marijuana or alcohol, then if the child is adjudicated a delinquent child in the delinquency system, then I think that the therapeutic courts, such as the drug court for juveniles in the delinquency system, or any other diversion programs, if the juvenile court feels they're appropriate, would still be applicable. So I don't see this as replacing the therapeutic courts for juveniles, but providing more diversion before you get there. And if I'm wrong, maybe Ms. Duffy will correct me or anybody else. But I think this would help divert kids, but still allow them to get drug treatment or therapy without having to necessarily quickly be fast-tracked into the delinquency system.
Kendra Birchie for the record, just to make sure the intention's clear, that is our understanding as well. Just so the committee is aware, in Washoe County, individuals who are under the age of 18 for these offenses, they're not being placed in juvenile delinquency court right now. They would have that informal probation, which is why that's really important for us to not be changing and having for every offense that they would be subject to it as a delinquent act.
Thank you, Ms. Birchie. Thank you, Chair.
Thank you. I also have a couple of questions that are starting out very, very broad, and this is much more about how we deal with these cases and the enforcement mechanisms than your bill in specific. And I am curious about the process through which the controlled substances, whether it's alcohol or marijuana, are confiscated and if they're impounded.
Kendra Birchie for the record. We're all looking back to see if a law enforcement who is in the building has that answer. I don't know, to be completely honest. I've seen different things just from reading probable cause sheets, so I don't know if there is a specific policy and procedure, but I would just note that that's not in this bill, nor am I aware of it in the statutes that regarding these offenses, but that could be something that's specific in policy and procedure.
Assemblywoman Danielle Monroe Moreno, I think that would be in the standard operating procedures for each agency, how they would deal with those substances.
Okay, so the reason that I'm asking is that, like in adult court, I've also seen these citations for marijuana or for having alcohol in a public place, something like that. I've never seen a beer can impounded, but also it has to go somewhere, right? So that got me to thinking, do officers, and again, might be outside the scope of the bill or either of any of your expertise, but if an officer is, approaching a group of teens or 19-year-olds who have a whole case of beer, do they have the discretion to say, hey, I'm going to issue you a citation, confiscate the whole case and throw it away? What if it's 3 ounces of marijuana between 4 teenagers? Can they cite each one and take it, or can they arrest one of them for all 3 ounces? I know there are possession issues there and whatnot. My question is broader about how much discretion police officers or other peace officers have when they're interacting with juveniles or people between 18 and 21, and if it's different from what they experience with other adults, or with adults who they encounter.
Kendra Birchie for the record, I think that is an excellent question, and unfortunately one that is not in my expertise, and I would just hope that any law enforcement, if they're planning on testifying on this, would keep that in mind and answer your question.
And I'll clarify that this doesn't change my support for the bill. I'm just trying to get an understanding so that as we continue to move forward in this session and future sessions, we make good policy to help out kids. And with that, I don't see any other questions or comments, so we will move to testimony in support of AB 158. And I do see somebody present to give testimony in the room, and I will let you go first, and you'll have 2 minutes.
Hello, thank you, Chair Scheibel and committee members. It's great to be here in person with you all. I am Nick Shepak, Policy and Program Associate with the ACLU of Nevada. If we are serious about broader criminal justice reform and creating a safer and more just Nevada, we must start with how we approach juvenile justice. Leaders such as Assemblywoman Monroe Moreno understand this, and we are lucky to have her here in the state. After decades of punitive, tough-on-crime responses to youth crime misbehavior, there has been a noticeable shift in recent years surrounding juvenile justice issues in the United States. AB 158 seeks to continue that shift. The criminalization of marijuana and alcohol use has not benefited Nevada's youth. A growing body of literature shows that the first arrest actually increases the likelihood of continued contact with the criminal justice system. The policy of the state should not be to apply significant and brutal criminal penalties to age-appropriate behaviors such as juvenile experimentation with drugs and alcohol. This is not to say that the state should not address these issues, as early drug and alcohol use can have significant negative effects on both development and success. The state, however, should address behavioral health issues as what they are, health issues. By ensuring that children are not arrested when they are caught for these things, unless they are in immediate danger, we reduce both trauma and recidivism. While we would like to see all criminal penalties removed from activities related to behavioral health issues, this bill prioritizes direct services and small penalties for Nevada's youth, which is the right way to approach this issue. The war on drugs has failed our communities, especially communities of color, and this bill will have a great impact on all Nevada youth, but a disproportionately positive impact on Nevada's youth of color, and we urge you to support AB 158. We thank everyone who worked with us on this legislation.
Excellent job coming in at exactly 2 minutes. And I don't see anybody else hopping up to give testimony in support in person, so we will go to testimony in support on the phone.
Thank you, Chair Scheibel. To testify in support of Assembly Bill 158, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 158, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 377, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon. My name is Deshaun Jackson, DASHUNJACKSON. I serve as the Director of Children's Safety and Welfare Policy with the Children's Advocacy Alliance. And we stand in support of Assembly Bill 158. We believe this bill is crucial to ensuring that youth are treated as youth. As Assemblywoman Danielle Monroe Moreno stated, we are all once youth. We all make mistakes. This gives youth the opportunity to fix and mend those mistakes that they have. We all are at fault at some point, but this bill is great. We thank Assemblywoman Danielle Monroe Moreno, the bill sponsors and co-sponsors. Thank you all so much.
Thank you, caller. Caller with the last 3 digits, 035. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the committee. For the record, my name is Quentin Savoy, Quentin, last name, S like Sam, A like Apple, V like Victor, WOIR. I'm the Deputy Director with Make It Work Nevada. We organize Black women and Black families around economic justice, racial justice, and reproductive justice issues. As such, we support AB 158. AB 158 is a measure that meets the current moment we're in, a reckoning of racial inequity that is seemingly baked into the fabric of our country. Nationally, we've continued to see Black and brown youth killed at the hands of law enforcement, while locally, critics of AB 158 are consistently trying to keep our youth, our young people, and our future incarcerated because of cannabis or alcohol possession. By now, you know that the status quo disproportionately impacts Black and brown youth, wrapping them up in a justice system that derails their possibilities and potential. During the summer of 2020, this body declared racism to be a public health crisis unanimously. This declaration brought our community some assurance that our elected leaders understood the weight of the moment we're in. This bill is an opportunity for you all to rise to that moment. It is an opportunity for us to show some compassion for our youth and ensure that they have a second chance before throwing them away by way of the justice system. AB 158 is community-driven policy that will keep our young people from being unfairly targeted by a justice system that is often more harmful than helpful to the young people who look like me and the families we work alongside. We urge bipartisan support for Assembly Bill 158. Thank you for your time.
Thank you, caller. Caller with the last 3 digits, 087. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Thank you, Chair Scheibel and members of the committee. My name is Jared Luke, Jaredluke, Government Affairs Director of North Las Vegas. I'd like to thank again Assemblywoman Monroe Moreno for bringing another great bill to the table. I can't really add anything that you folks haven't already discussed or that has already been stated in support testimony, but I want to throw support behind AB 158 and just say that I have kids and I talk to them all the time about, I remember what it was like being a kid, but you've never been an adult or a parent. And I think oftentimes we as adults, we really do. We forget what it was like being a kid. We forget about the social pressures. We forget about peer pressure. We forget that a lot of the kids that we ran with possibly didn't have a great family structure, parents at home that helped teach them, that were home during the day. And maybe these kids don't have the correct coping strategies that or coping mechanisms that they need. So this is a very thoughtful and a creative approach to alternatives to immediate arrests. And I think that if this program passes, if we can get this bill through, I think it's going to show that it's going to yield greater results in corrective behaviors with youth. I thank you for listening to my testimony, and I, again, urge passage of this bill.
Thank you, caller. Caller with the last three digits, 611, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Judiciary Committee. This is John Pirro from the Clark County Public Defender's Office. And we'd just like to urge your support for this measure and like to thank Assemblywoman Danielle Monroe Moreno for bringing this bill forward. Thank you.
Thank you, caller. Caller with the last three digits, 147, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary. This is Bridget Duffy, Brigid Duffy, Chief of the Juvenile Division for the Clark County District Attorney's Office, appearing today on behalf of the Nevada District Attorneys Association in support of AB 158. I want to thank Ms. Goins, who was just great to work with through the process, and Assemblywoman Danielle Monroe Moreno for bringing forth this important issue. I know I have some highlights I need to hit based upon some questions. First of all, I want to say that the actual bill that is in front of you as the amended bill, it really makes statutory the process that's already in place in Clark County. In fact, I got a little ahead of myself when Ms. Goins called me and was all excited about being able to really put our process in statute, and then remembered I'm a small part of a much larger state. So as Ms. Birchie had mentioned, there are a lack of diversionary programs in other parts of our state that we are fortunate enough in Clark County to have. So first of all, I want to also clarify and agree that our number one referrals to the juvenile justice system in Clark County are marijuana possession and battery, number one being battery, number two being marijuana possession. But I want to make very clear, the DA's office doesn't file those cases. Those are referrals, and referral is a term of art in juvenile justice. It means that it could mean a couple things. One, it could mean that the child received a citation or a ticket, would be a common word, or it could mean an arrest as well. Of course, most of those, if not all of those, are citations and not arrests. The district attorney's office is not in the habit of filing first-time referrals for marijuana and battery charges. In fact, those two charges also account for 78% of all the referrals to our harbor program in Clark County in the year 2020. So those two charges are also our number one diverted charges out of the juvenile justice system. I also want to make clear that the portion about the 432B shelters being excluded as a possible placement is really because I don't want to start another problem for the family, which is opening up a Department of Family Services or a CPS case, because anytime a child is left at the doorstep by law enforcement or any other party at an abuse and neglect shelter, it mandates that Child Protective Services open up an investigation in order to receive that child. So we don't want to stop one problem to start another for a family. So that is why it's very important that we exclude those shelters as a drop-off point if a parent cannot be notified. I want to address Senator Pickard's concerns, I do not see that for the juvenile system that this will impact our use of diversionary programs. Our first offense chins would go to a harbor program. The second offense, as Senator Orenshaw pointed out, we would still be able to use diversionary programs specifically because we reference Chapter 62C200, which allows for use of cognitive training and human development classes under 62E220, which would then be those development, those skill building classes. So all of those things we currently use are now statutorily required for the second offense. So I think that addresses the questions that came up. I don't know, Chair Scheibel, you want me to stay on if there are any questions? I know I don't usually do that on the phone, but that would conclude my support and what I felt I needed to clarify. Thank you.
Thank you so much, Ms. Duffy, and I am going to break my own rule and allow you to stay on the phone because you are a subject matter expert in this area, and the sponsor of the bill is not looking like she's going to jump up and tell me to stop. So if there are any questions, I will allow them. Go ahead, Senator Pickard.
Thank you, Madam Chair, and thank you, Ms. Duffy. As I expressed before, my concern is just I don't want to hamper the ability to do the diversion programs since they have proven to be really successful up to this point. And I was under the impression that that was occurring around the state, so apparently not. But so at least in Clark County, it's my understanding then from what you just said that because of the reference to 62C and because the second tier allows us to essentially gives the Department of Probation, Juvenile Probation, or the Department of Probation the ability to make the determination of what the appropriate next step is, that we're not going to undermine the existing diversionary programs. Is that correct?
Bridget Duffy for the record. Thank you, Senator Pickard, for the question. Yes, that is correct. It would be, this is business as usual in Clark County, and it actually will now mandate so that we can make sure that that business as usual maintains after Jack Martin and I are gone, and the diversionary programs could be used by the probation department.
Great. Thank you so much. I appreciate that.
Thank you, Ms. Duffy. And with that, we'll move on to the next caller, if there's anybody else in line to give support testimony on AB 158.
Thank you so much, Chair. Caller with the last three digits, 740. Please slowly state and spell your name for the record. You'll have 2 minutes to speak. It may begin.
Hi, this is Katrina Saunders. Thank you, Senate Committee, on speaking on this subject matter today on Senate Bill AB 158 in regards to juvenile possession justice reform. I think it's important. I myself have a 14-year-old that just got in trouble for having a vape pen in Wisconsin last week, and they gave him a $125 fine, and it'll be on his record till he's 18. I'm glad that in the state of Nevada, people are making efforts to make adjustments so that our youth won't be penalized and have their life ruined and on their record. Moving forward, I am in support of this bill, and I'd like to thank everyone who supported and bringing this awareness so that our youth will be able to have a normal life and won't be filled with penalties for small amounts of cannabis possession. So thank you. You guys have a great day.
Thank you, caller. Caller with the last three digits, 840. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin. Once again, caller with the last three digits, 840. You are unmuted. Please slowly state and spell your name for the record. You'll have 2 minutes to speak. It may begin.
Good afternoon. My name is Tamara Favors. It is spelled Tamara. Favors, Favors, and I'm with Make It Work Nevada. I am the ambassador coordinator, and we stand in support of AB 158. This bill will remove any chances for a youth to have a misdemeanor related to marijuana, having marijuana or alcohol possession. When you throw young people in jail, all they're doing is sitting in a 4x4 cell. and learn nothing productive, their time is not being useful. This will give the ability for youth to not have a record. For instance, the youth will for instance, if a youth is either black or brown, having a record has different consequences than someone who is not black or brown. This legislation will require juveniles to perform community service and allow them to be productive and engaged in their communities. This bill will not be a good use of the state's money. We urge bipartisan support in AB 158. Thank you.
Thank you, caller. Caller with the last three digits, 130. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and maybe can.
Good afternoon, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINE on behalf of the Progressive Leadership Alliance in Nevada. I will just echo the sentiments of those who spoke before me and also urge your support of this legislation. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide support testimony at this time.
Thank you so much. I believe we do have somebody on Zoom, Ashley Dodson, to give support testimony. And you may go ahead whenever you're ready.
Thank you, Madam Chair. Hello and good afternoon, everyone, members of the Senate and committee. My name is Ashley Dodson, spelled ASHLEYDODSON for the record. I am in support of AB 158. I am the co-founder and president of the Cannabis Equity and Inclusion Community. I am also a licensed social worker and mental health specialist with a master's degree in social work from the University of Southern California with an emphasis in children, youth, and families. I have been an advocate and mentor for juveniles since 2010, working with programs such as Bully Buster 702, several youth church organizations, and several behavioral health agencies, where I have firsthand worked with juveniles who have been mandated by the courts after being detained for marijuana possession, many which who were using as coping mechanisms due to family household issues, bullying and behavior issues in school, depression, lack of support, and so on. As a once curious youth and now mother of 5, most children want and need compassion, someone to talk to, guidance, an opportunity to be educated, and create an opportunity for prevention. Today, I am presenting in support of AB 158 as amended to end the criminalization of juveniles under the age of 21 who are charged with possession of cannabis in their first offense. Statistics from the Juvenile Justice Report in Nevada are as follows since 2017. These statistics, of course, in regards to possession of marijuana, which are always number 2 after battery. Since 2016, there was 952 referrals and has gone up. 2017, 984, 2018, 993, and 2019, 1,009, which was the highest ever. I strongly believe that Nevada has alternative resources, advocates, and programs available to prevent the school-to-prison pipeline and decrease the recidivism on juveniles by providing rehabilitation and education, especially for Black and brown youth who have been disenfranchised by the war on drugs. Juvenile detention can be harmful and mentally and emotionally harmful for children as well. Children who have been physically and emotionally separated from their families and community have higher rates of depression and suicidal ideations. According to the recent literature found in the Justice Policy Institute report of youth corrections, shows that detention has profoundly negative impact on young people, mental and physical well-being, their education, and their employment. One psychologist found that 1/3 of incarcerated youth diagnosed with depression, the onset of depression, occurred after they began their incarceration. 6 and another suggests that poor mental health and the conditions of confinement together conspire to make it more likely that incarcerated teens will engage in suicide and self-harm. With AB 158, opportunities for positive outcomes for our youth will be visible and decrease the negative impacts of detained children who are still in their developmental stages. Education is key. By giving our youth another chance to improve behavior, be properly assessed for mental health conditions, and be appropriately assigned to community service, will decrease the likelihood of juvenile possession convictions. According to the Office of the District Attorney of Nevada, African Americans and Hispanics make up 77% of the referrals by the DA to adult court. Since 2019, possession of cannabis charges has increased amongst our youth since legalization. There will still be over 1,000 cannabis possession charges referred to juvenile court since that time, and the numbers continue to increase. Research from the Office of Juvenile Justice and Delinquency Prevention provides evidence-based programs and models that promote promote prevention, interventions, and reentry. Research shows that youth cognition and participation in risky behavior is associated with biological immaturity of the brain and with an imbalance among developing brain systems. Hence, they are not operating at capacities of an adult, which in turn, they should not be charged criminally in the first offense. Not only is this costly, it is traumatic for the youth being charged and often detained. Restorative justice will decrease these alarming disproportionate numbers representing Black and brown youth. Public safety will be maintained, job and vocational skills will be developed, rehabilitation and addressing treatment needs will promote mental wellness, all leading to successful reintegration of our youth into the community. Economic relief will also be brought to taxpayers with restorative justice as it is more costly to house youth in detention centers and facilities. Research done by the University of Southern California suggests that youth programs in California showed exponential drops of recidivism. At the time when this was written, 10% compared to the 60 to 70% nationwide, and high participant satisfaction. Due to this process, tens of thousands of dollars per each case are saved and preventing recommendation to detention centers. The federal government provides grant funds and programs which advocate for restorative justice models instead of traditional punitive systems. Such funds can be awarded to Nevada with program models seeking to train and educate the youth to become thriving, law-abiding citizens and refraining from re-entering into the correctional system. Now is the time for Nevada to support our youth by providing the resources they need and acknowledging cannabis offenses as the opportunity to provide education and empathy, as well as rehabilitate them to a higher and brighter future. It is socially unjust to continue to see these children and youth disproportionately affected by the war on drugs, impacted negatively due to the lack of empathy, cultural competency, diversity, and inclusion. Communities progress forward when justice is distinguished as a basic right, and this legislation provides an opportunity for Nevada to save our youth. I respectfully urge you to support in AB 158 as amended. Thank you, everyone who has worked on this legislation.
Thank you so much for your comments. Thank you so much, Ms. Dobson. And if you wouldn't mind, it looks like you had prepared those in advance. If you could send those to our secretary to make the creation of the record easier, we would appreciate it. The email is on our website, or you can always contact me to get it for you. And I believe that concludes testimony in support of AB 158, unless I missed anybody on Zoom or in the hearing room, but it looks like I did not. So we will move to testimony in opposition to AB 158. I don't see anybody present to give opposition testimony, so we will go directly to the phones. Mr. Kyle, please.
Thank you so much, Chair Scheibel. To testify in opposition on Assembly Bill 158, please press star 9 now to take your place in the queue. Once again, to testify in opposition on Assembly Bill 158, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
All right, then we'll go to testimony in neutral on AB 158. I don't see anybody coming to the table, so we will go to the phone lines, please.
Thank you, Chair. To testify in neutral on Assembly Bill 158, please press star 9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 158, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide neutral testimony.
All right, thank you so much. That concludes testimony on AB 158. Would the presenters like to make any closing comments? Come on up. And it looks like Senator Pickard still has another question, so I'll invite Assemblywoman Monroe Moreno back to the table.
Thank you.
We'll do the question first.
Thank you, Madam Chair, and I apologize. Thank you for the second bite. I just, something that just came to mind as I'm reviewing my notes. I'm in Section 4, Sub 5. A person under the age of 21 fulfills the terms and conditions imposed for a violation of subsection 4, which would include the first offense. The court shall, without a hearing, order sealed all documents and on. My concern is this. How do we get to a second offense if nobody knows about the first offense? Are the records sealed only to the public, but the judicial system knows about it? I don't know the answer to this question. So how does this work, and how do we get to a second offense if, in fact, the first offense was sealed?
Kendra Birchie for the record, and if I may, Madam Chair, or Chair Scheibel, Senator Pickard, if you don't mind, I think that I'm happy to have this discussion with you offline in further details. I do think that this was, just so you know, this was something that we had discussed at great length with the district attorney's office, and this was agreed upon information. It's my understanding that they would be able to still have that, so I'm happy to speak with you with them as well.
And that's fine. I just, it popped into my mind, and so we can do that offline, and maybe I'll ask the DAs as well. But I think it's important. I think that may be something that we might want to look carefully at before we move this bill, because I think that the intention, and I agree with the intention here, right? It's to get the kids the help they need, particularly if we can get them into harbor programs all over the state. I think that's really important. But if we can't see, and I don't know how the system works, but if we can't see that first offense the first time it comes up, it's going to be Groundhog Day. We're going to have multiple first offenses, and they're not going to get the help they need, is my fear. So anyway, we can take that offline. Thank you, Madam Chair. I do appreciate it.
Sure, and I'll also just chime in here that also assumes that the second offense is occurring after all of the conditions have been met for the first offense. And in my practice, what I often see is that it's while the first offense is still pending that the second offense or the second arrest occurs. And so then those individuals would be treated under subsection B with those requirements and so on and so forth. Now, if you'd like to provide any closing comments and answers to Senator's questions.
Kendra Birchie for the record. If I can, I did receive a text message from the Nevada Association for Criminal Justice, the Nevada NACJ, asking me to put their testimony of support on the record.
Assemblywoman Danielle Monroe-Moreno, and thank you, Madam Chair, for allowing us to present today. But you had to ask a question about what happens with the items. And speaking to one of my law enforcement colleagues, it is different with each department. However, with liquids, you can't always impound those, so those are disposed of. With the other items, they would be impounded.
Thank you. That's good to know. And with that, I will now close the hearing on AB 158. Again, we appreciate all of you being here to testify and answer our questions. At this time, I will open the hearing on AB 33. And I understand our presenters are here via Zoom in this for this bill.
Hi, good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. Thank you very much for the opportunity to present AB 33 to you today. My name is Dagny Stapleton, Dagny Stapleton. I am the Executive Director of NACO, the Nevada Association of Counties. With me today are three presenters who will go through this bill and provide testimony for the committee, and I'd like to introduce them. First, Amber Howell is the director of Washoe County's Human Services Agency. That agency oversees the child welfare system in Washoe County. Because of her role, Director Howell is very familiar with child welfare and dependency cases and the process for determining paternity, which our bill today addresses. Also, to help us answer any technical or legal questions representing Washoe County is Megan Lucy. She will walk us through the bill when we get to that point. And finally, we are honored to have retired Supreme Court Justice Nancy Sato with us. She will also share her perspective on this issue with the committee. With that, Chair Scheibel, I'd like to turn the presentation over to Director Howell.
Good afternoon, Chair Scheibel and members of the committee. For the record, Amber Howell, AMBERHOWELL, Director of Washoe County Human Services Agency. I wanted to just mention that start off by saying really the greatest gift that we can give a child is closure through a forever home after they've been abused and neglected or experiencing things that we wish that they had not. No child or parent should have to mourn the loss of each other, but when it does occur, we need to not prolong those steps. The quicker we can remove the anxiety from a child that is worrying about where they will be placed for the last time and free from the instability, the quicker that the child can close that chapter and begin anew.
Children in the foster care system endure unanticipated trauma from the unknown, and not having a secure placement or confidence that the adults in their life will stay there and be there forever impacts all of the facets of a child's life. Children should not grow up in our system, and the second we realize that that is not an option for reunification with the parents, we need to move quickly and have a seamless process to find the next best option. Federal timeframes and court processes and establishment of paternity all take several months, and we want to have it as seamless as possible so that we can shorten those experiences for a child. I want us just to think about a child's clock. For most of us, we think of a lifetime as 70 to 80 years, but for a child, they spend a very little amount of time being a child. And when you think about a child in the foster care system who it may take 4 to 5 years to get adopted, that becomes a fourth of their childhood that's spent in the foster care system, and they really can't get those years back. And so we need to preserve as many as we can. This legislation addresses the legal process that needs to take place when kids in foster care and adoption is the next path. In dependency hearings, in order to ensure that the biological parentage of a child is resolved, the process for determining paternity must occur. This bill ensures that this process is uniform and efficient across the state by making sure that the existing processes in law in Chapter 126, where the adoption proceedings are also used in the child welfare cases as well. In summary, I will end by saying that we don't believe that any parent wakes up one day and decides to be absent or not provide for their children. But in various instances, this does occur, and we need to be there for the child to provide an alternative plan that is safe, loving, and secure. Everybody longs for a parent to guide them and to teach them and love them unconditionally. And when biological parents cannot meet these tasks, we need to have processes that streamline the myriad of events that need to occur in the child welfare system. This legislation is being proposed to provide clarification to give children as much time on their clock as possible. Thank you so much for the opportunity to testify today. And I will turn it over to Justice Nancy Seda.
Good afternoon, members of the committee. Madam Chair, it is my privilege to speak in support of this most important bill. I want to make it very clear that this bill does not eliminate establishment of parentage. It simply streamlines the process. This means that we are taking from one section of our statutory scheme, moving into another, an expedited, if you will, a more efficient way to free our children for a final permanent home. It is perhaps of little note to today's hearing, but it means the world to me. Today happens to be my birthday. And although the decades don't matter, there's not a birthday that goes by that I don't thank the people who gave me the privilege of being adopted into the home where I landed. And the process that we put before you today in AB 33 simply allows for that window of time, that short window of time for our young kids to get into that permanent home that, from my perspective and from the years that I've worked in this area, will make all the difference in their lives. We are not eliminating the right to contact, to identify, and to have present all parents. We are simply making it a more efficient process by combining the two areas of law into one and allowing the adoption process, the permanency process, to move forward more efficiently. I can't thank you enough for considering this because, as I said, it surely makes a difference in so many lives. For myself, certainly my parents, my adoption meant all the world to me. So thank you for your time and your attention.
Good afternoon, Chair Scheibel and the rest of the Senate. My name is Megan Lucy, spelled MEGAN LUCEY. I'm speaking today on behalf of Washoe County Health and Human Services Agency, and I will direct you to the bill to go through the proposed amendments, as well as answer any questions that you may have regarding this process that we're requesting here today. At this time, I'll direct you to the proposed bill, AB 33, as drafted and provided to the Senate today. As you can see, there are minimal changes that we are proposing to the already existing paternity statutes under NRS 126. We are simply, as already discussed with you here today, trying to streamline the process to establish paternity in these particular hard cases in the dependency community, and simply allow these processes to provide more seamless process for these youth. So as you turn to section 12 of that proposed amendment, we're simply adding additional language to allow paternity to be established for the mothers in sub 1 and the fathers in sub 2 under 432B dependency statutes. These are already existing paternity laws that help and assist family courts throughout the state. We're simply allowing them to be added to these particular dependency actions. If you scroll down to section 12.3, you'll see additional proposed language. Again, all it does is simply allow the jurisdiction of the district court to attach paternity establishments to the dependency 432B cases. Again, this is a process that can be done already through the district courts, but this streamlines it so it can be done in one action with one judge and not take up additional judicial resources and additional time with the children in their youth, particularly in foster care or in their guardianship placements. If you scroll down to sub 6 of 12.3, we are simply allowing the 432B dependency actions to become final orders of the court, which allows them to be appealed, which is necessary for the judicial rights of these parents. And additionally allowing that these orders, these paternity statute orders, once entered into by the district court, be allowed to be published and not subject to the confidentiality provisions of 432B actions. This is important because all of the orders and all of the proceedings within 432B dependency actions are subject to confidentiality provisions, given the sensitive nature and the impact that they have on minor children throughout the state. We are simply allowing these orders that establish paternity to be deemed unconfidential for the purposes of changing birth certificates or other various uses of these orders, so they are not then in violation of the already established confidentiality provisions required with these particular cases. That concludes the totality of the requested amendments pursuant to AB 33, and I appreciate the opportunity to speak with you here today and welcome any questions anybody may have.
Thank you so much. Does that conclude the presentation, Ms. Stapleton?
Yes, it does, Chair Scheibel, and we'd be happy to take any questions.
Well, I'm sure we will have some for you. Senator Pickard.
Thank you, Madam Chair. And I guess I'm going to address Justice Seda, if I may, in this question, because as a former justice of the Supreme Court, you will have dealt with jurisdictional questions on a regular basis. And I am under the impression that these determinations are made at least in the 8th Judicial District all the time, under the idea that the family court, of which dependency is division, has plenary power. In fact, their jurisdictional limits are greater than the other district courts in that they can hear these family matters where the other district courts cannot. And so do they not already possess the authority under 126 to establish paternity in order to make the determinations necessary under 432B? Because I don't believe they're currently doing that in a separate action. I think they're doing it as a matter of course. Maybe they're doing it out of necessity as opposed to statutory authorization. But can you inform me, educate me a little bit on the jurisdictional question and whether or not they are actually acting extra jurisdictionally in this case?
Senator, to you through the chair, all this bill does is to make that process that you described clearer and simpler. Yes, the jurisdiction attaches to the individual family division of the court. But all we're doing is taking it from one section and putting it into the other so that it is very clear for all of our judicial officers to know that they can put the paternity action within the 432B action. That's all we're doing. It has nothing to do with establishing or enlarging jurisdiction. Obviously, our judges are doing it right. They're just doing it in a truncated process, and this will simply make it easier. That's all the request is in this provision.
All right, and I appreciate that. Thank you very much. And by the way, it's great to see you. Haven't seen you since a Children's Commission meeting, so look forward to those kicking back in. But in my discussions with Ms. Stapleton and others prior to this, it's my understanding this is not occurring, or at least the districts outside of the 8th Judicial District are not currently interpreting this way. So do I understand correctly that what this is going to do then is it's going to standardize the practice everywhere so that I'm assuming then we have separate actions in these cases in the other jurisdictions, particularly where we don't have a family court. So is this going to then standardize for everyone what the 8th Judicial District has been doing for some time?
Again, Senator, to you through the chair, the simple answer to that question is yes. And absolutely, it will establish a clear line, if you will, a clear pathway to creating, again, a quicker permanency process. It's already in place. It just makes it easier, more streamlined. I guess we keep using that term. The fact of the matter is, yes, we will continue to do what we've been doing, just in a simpler form.
Perfect. Thank you so much. I appreciate it. Thank you, Madam Chair.
You're welcome.
Absolutely. Senator Orenshaw.
Thank you very much, Chair Scheibel, and it's great to see Justice Seda. And this session, just as an aside, we've been working on a lot of legislation with the Statewide Commission on Juvenile Justice Reform, and certainly your hard work, along with First Lady Sandoval during the 2017 session on Assembly Bill 472, has really, I believe, improved outcomes for children in our state in the juvenile justice system. And I want to thank you for that. And I think it's a work in progress, and it's still moving forward, and I think you have a lot of thanks to be given for that. My question on the bill, for whoever would like to answer, maybe someone from Washoe County might have more information, and I apologize for my ignorance because I don't practice in this area, but if this passes and with this streamlining, if there is a putative father who was not listed on the birth certificate, perhaps who was not aware of the child, would this reduce the amount of time they'd have to establish paternity, or would they still have the same rights that they would currently have under law?
I can take this through the chair to the senator, Megan Lucy, on behalf of Washoe County Health and Human Services Agency. No, this would not reduce the opportunity for any putative fathers to step in to establish any rights or responsibilities that they may wish or they may have with any particular child. This just streamlines the process for establishing paternities with those families and with those cases that paternity is at issue and unknown. This is established through the 126 paternity statute as stated, so DNA testing can be utilized to conclusively establish a putative father or mother in this particular case. And streamline the process for that child to continue down the path of forever homes through the termination process as deemed necessary. So no, it does not impact the rights of any putative father or putative mother that may want to come forward and establish rights through those processes.
Thank you, Ms. Lucy. Thank you, Chair.
All right, any other questions? Well, I would like to wish you a very happy birthday, Justice Seda, and I'm so honored you chose to spend it with us. We very much appreciate it, and all of your service to the state of Nevada. And we will now move to testimony in support of AB 33. I do see somebody here live and in the flesh to give some testimony, so we will start with you, and you will have 2 minutes.
Good afternoon again, Chair Scheibel, members of the Judiciary. This is Kendra Birchie with the Washoe County Public Defender's Office. For those of you who do not know, my office also represents the parents in these 432B cases. We did work with the sponsors on this bill, and I do really appreciate the additional protections that they put in place to ensure that the due process rights, that there are appellate rights, and that those are maintained with this revised version that you see. As to Senator Orenshaw's question, I would just say that I do believe that this bill does improve the timing. I can say that I represented kids at Washoe Legal Services, and I did have a child who had a putative, non-offending parent, where this bill would have assisted in getting him quicker placed into that home. So we do support this legislation and urge your support as well. Thank you.
Thank you. I don't see anybody else in the room to give testimony, so we will go to testimony on the phone in support of AB 33.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 33, please press *9 now to take your place in the queue. So again, to testify in support on Assembly Bill 33, please press *9 now to take your place in the queue. Caller with the last three digits, 819, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Thank you, Chair Scheibel and members of the committee. This is Kimberly Surratt, S-U-R-R-A-T-T. I'm an unpaid lobbyist and the current president of the Nevada Justice Association. The Nevada Justice Association is in support of AB 33. As you all know, parentage is often the focus of my testimony at the legislature. This bill is a good example of minor changes that can be made to give Nevada children consistency in our state. Our children deserve consistency, and they deserve judicial efficiency within the family law arena. Yet we often fail to do that because we often fail to make minor changes to make that happen. This is a minor change with a big impact. There was a quick comment in the testimony about Chapter 126 and adoption. Chapter 126 is parentage, has nothing to do with adoption. I think it was just a slip up in the comment, but I wanted to make sure the record was clear. We thank NACO and Ms. Lucy for being resilient and bringing this bill. And my last closing comment is that I'm lightheartedly very thankful for just a 2-minute time limit on me today. Thank you, everyone.
Thank you, caller. Caller with the last three digits, 261, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Thank you. Good afternoon, Chair Scheibel and members of the committee. My name is Jillian Block. That's Gillian Block, representing the Nevada Coalition of Legal Service Providers. I just wanted to quickly say that we are also in support of AB 33 because, as the presenters today noted, this bill will bring statewide uniformity and consistency to our statutes. We know that delays in permanency are bad for children, and AB 33 will help reduce delays. And thank you so much for your time today.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide support testimony at this time.
All right, we will move to testimony in opposition to AB 33. There is nobody in the committee room to give testimony, so we will go directly to the phones.
Thanks, Chair Scheibel. To testify in opposition on Assembly Bill 33, please press *9 now to take your place in the queue. Once again, to testify in opposition on AB 33, please press *9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
All right, then I will move to testimony in the neutral position on AB 33. There is nobody present in the room to give such testimony, so we will go directly to the phones, please.
Thank you, Chair. To testify in neutral standing on Assembly Bill 33, please press *9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 33, please press *9 now to take your place in the queue. And Chair, there are no callers to provide neutral testimony at this time.
All right, thank you so much. That concludes the testimony on AB 33. Do the presenters have any closing comments?
Thank you so much, Chair Scheibel. That was Nicholson for the record. Just to thank you for hearing the bill today.
Well, thank you for being here to present it, and I hope that Justice Seda will go do something more fun to celebrate her birthday, and that all of you have a wonderful afternoon and weekend. With that, I will close the hearing on AB 33. We will go to the last bill on our agenda today, and I will, nope, we have two more bills on our agenda, sorry. We will go next to AB 112. I will now open the hearing on AB 112.
Good afternoon. Thank you, Madam Chair and members of the committee. For the record, I'm Assemblywoman Elaine Marzola, representing Assembly District 21 in Clark County. Thank you again for the opportunity to present Assembly Bill 112, which revises provisions related to compromise of a claim of a minor. To start with some context, a compromise of a minor's claim refers to a settlement of a disputed claim for money damages in a personal injury claim on behalf of a minor under the age of 18. In Nevada, if a minor is injured in an accident caused by the negligence of another person, just like an adult, the minor is entitled to seek recovery from the negligent party. Existing law states that if a minor has a disputed claim against a third party, the parent or guardian of that minor has the right to compromise the claim by filing a verified petition with the court. If the court approves the compromise of the claim, the guardian or the parents must establish a blocked savings account. The revisions in Assembly Bill 112 simplifies and streamlines the compromise compensation process by allowing parents or guardians to more readily use funds for the small claims awards for the benefit and best interest of the child. At this time, Madam Chair, I would like to turn the presentation over to former Nevada Assemblyman Justin Watkins to present specific details of the bill itself and to answer any technical questions.
Go ahead whenever you're ready, Mr. Watkins.
Thank you, Chair Scheibel and members of the committee. It's a pleasure to be back in front of you. And I want to thank Assemblywoman Marzola for bringing and sponsoring this bill. While it's a minor change to minors comp statutes, I think it's an important policy change to make. So as the Assemblywoman stated, the current process is no matter what value, how big or small a case is in results of a personal injury, whether it's a car accident, a slip and fall, a fight at a school, what have you, the parent can't do anything with that money, can't even settle the claim without the court's approval of that. And once the approval occurs, then that has to be done through a petition with the court, and there can be some strings attached to that, such as yearly accounting for the funds, what bank you deposit them in, and then some other filings when the child turns 18 and becomes age of majority. The first part of this bill seeks to just update the language associated with it. The language says a depository account, and while the courts have interpreted that, I think, reasonably in recent sessions, the idea is that we want to give as much flexibility to the courts as possible to allow that money to be put into a financial institution, an investment account, especially in today's day and age where savings accounts are earning less than a single percent, to try to grow the money in a more favorable way for the minor. The second change is a little bit more substantive, and that is to say that it is a discretionary tool that we are providing to the courts, that when the amount of the compromise, the settlement, is smaller, and the threshold we've chosen in this bill is $2,500, that the court, in its discretion, can award that money directly to the parent for the use and benefit of the child without any further reporting required or depository into a blocked trust account. It's not something the court has to do. It's just another tool in the the toolbox for the courts to do. And the reason why we tried to address this issue is because in practice, what I see is when we have low dollar valued cases, and I'm just going to use a simple example. You're in a car accident, you're hurt as the adult, but the child seems fine. Most parents, reasonably so, are going to go take their child to go get checked out. They may go to the emergency room with the adult and get checked out there. Their bills may be $400 or $500, and an ultimate resolution of that claim may be about $1,000, and the money going to the minor after all the medical bills are paid are a couple $100. And in that situation, because of all the hoops the hurdles that must be cleared by the parent and the lawyer, frankly, I think there are a number of instances in which these claims get passed over. They're not made because the system is too arduous. And so with the idea that we can file a petition with the court, get the money to the parent, and it's done and closed, and there's no yearly accounting, and the lawyer doesn't have to track the case for a dozen years and remember to contact the child when they turn 18 to get the money released, I think that you're going to see all the appropriate claims made that should be. And that's the two minor changes that we're making to the statutes in a nutshell. And I stand ready for questions.
Thank you both so much. Do we have questions from members of the committee? Senator Pickard.
Thank you, Madam Chair, and it's thank you for bringing the bill. It's great to see you, Assemblyman Watkins. Enjoyed working with you a couple sessions ago. My first reaction to this was, of course, this makes sense. I've experienced these both as a PI lawyer in the past and as a family lawyer, but it's that experience that I want to make sure we're clear on the record. Because often what will happen is the parents will be entrusted with the account or with the money. They have to set up the account. It's a block account, which means the parents can't just go pill for the money. And in my latter, in the second instance I'm talking about, we often see these things abused if they're not in a blocked account, where one parent will take the entirety of the account, and now that's an issue in family court, whether it be a divorce action or a custody action. So as I read this, it says, in compliance with any terms and conditions ordered by the court. So what I'm envisioning is a situation where the parents are together, they're getting along, everything's fine, they put it in an account, in whatever type of account they put it in, and then the split happens, whether it's a custody issue or a divorce issue. Now they're going to be, it's not much money, but they're going to be fighting over it. They always do if we're in litigation. So how does a court, because typically it's the civil court that will retain jurisdiction to oversee the account. How do we then process this in a divorce or custody situation? Does that district court have the authority to take jurisdiction over this account and order its disposition? Or does the civil court that issued the order retain jurisdiction? How do we resolve that in this scenario?
For the record, Justin Watkins. Thank you, Senator Pickard, for the question. So I'm assuming from your question that we're taking into account that this is a settlement amount of under $2,500. The court has utilized its discretion that we're granting in this bill to give that money directly to the parents for the benefit and use of the children or the child. In that situation, I believe jurisdiction would end upon that order. Current law is that it has to go into a block trust account, which must be maintained and accounted for with the court until such time as the court orders release. If they were to use this portion of the bill that we are giving them as a tool, then their jurisdiction would end there. If then there is a split and we're in family court and they bring forward those funds as part of assets that need to be divided, then I believe that it would be the family court's jurisdiction to do so. However, I wouldn't anticipate that to be something that would actually be accounted for, because I would imagine in my practice, if I were going to try to utilize this provision, that the court would want to see in my petition what the parents plan to do with the money, whatever small dollar amount it was, whether it's, the settlement amount is to go to the minor is $200, and the minor wants, I don't even know, a trip to Disneyland or use it towards something that the minor wants that maybe the family wouldn't otherwise have been able to afford, then that money would have been spent and there's nothing there for the family court to divide. But assuming that there is still an accounting of those funds, then it would go to the family court to divide, unless the civil court retained jurisdiction by requiring accounting until the age of majority.
All right, and so you've assumed the correct, I don't want to say correct, but the facts I had in my head. And I had actually envisioned where we would have a multi-party situation where maybe the kids and the parents were involved in an automobile accident, and this would be a compromise for the child. But it's part of a bigger settlement issue, and so maybe they have. And I had a situation, although it was a blocked account, so they didn't abscond with the money. One of the parents tried, and so that's why this is fresh in my head. And I guess my hiccup was over when it says the court may at its discretion close the case. But just because it's closed the case doesn't mean it's necessarily lost jurisdiction. That's why I wanted to have the discussion on it. But what you're describing sounds reasonable. If the court has divested itself of jurisdiction and closed the case, then it would be an asset divided by the family court. If the civil court did not say they did decide, and maybe the divorce was imminent or the disagreement between the parents was obvious, and the court decided to put that in a blocked account so that it could account for that money, then that civil court would retain jurisdiction, and then it would probably end up being something that would be brought up in the family court case, but the civil court would end up having to dispose of that money. So just wanted to make sure that was on the record. Madam Chair, thank you for your indulgence. But this, I think, without that kind of clarification, I think this could end up being a little bit of a new tweak in family court. So thank you for that.
All right.
And Justin Watkins for the record. Thank you, Senator Pickard. I think that accurately states the intent and language of the statute.
All right, other questions? Not seeing any, we will move to testimony in support of AB 112. I don't see anybody present to give support testimony, so we will go to the phone lines, please.
Thank you so much, Chair Scheibel. To testify in support on Assembly Bill 112, please press *9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 112, please press *9 now to take your place in the queue. Caller with the last three digits, 819, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
This is Kimberly Surratt, Surratt, again with Nevada Justice Association, but from the domestic side, family law side of our association, I am in favor of this bill. Thank you.
Thank you, caller. And with that, Chair, there are no more callers to provide support testimony at this time.
All right, we will move to testimony in opposition of AB 112. I don't see anybody in the room to give testimony, so we will go directly to the phone lines.
Thank you, Chair. To testify in opposition on Assembly Bill 112, please press *9 now to take your place in the queue. Once again, to testify in opposition on AB 112, please press *9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
All right, we will take neutral testimony on AB 112, and I don't see anybody here in the room to give testimony, so we will go to the phone lines. Please, Mr. Kyle.
Thank you so much, Chair Scheibel. To testify on neutral standing on Assembly Bill 112, please press star 9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 112, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide neutral testimony.
All right, then that concludes all the testimony for AB 112. Unless the presenters have any closing remarks, go ahead.
I just want to say thank you, Madam Chair and members of the committee, for the opportunity to introduce Assembly Bill 112, and I ask for your support. Elaine Marzola, Assembly District 21, for the record.
Thank you so much. I will now close the hearing on AB 112. I will open the hearing on AB 318.
Good afternoon, Madam Chair, and the other members of the Senate Judiciary Committee. And I appreciate the opportunity to testify in support of AB 318.
I'm going to pause you for one moment and allow Assemblywoman Marzola to start the presentation. And
I'm sorry.
That's okay. I appreciate the efficiency, but she wants to say something, so I'm going to let her.
And I appreciate her assistance in this.
I promise it will be quick. Thank you again, Madam Chair, as a member of the committee. For the record, I'm Assemblywoman Elaine Marzola from Assembly District 21 in Clark County. I'm here today to present Assembly Bill 318 for your consideration. With me today are co-chairs of the Legislative Committee for the Probate and Trust section of the State Bar of Nevada, Alan Freer and Mark Noble. Both gentlemen are experts in their field. Also to present this bill is Christina Kleist. I would like to provide some general background information before I hand off the presentation. Nevada is at the forefront of the estate and trust law. To a large extent, this is because the legislature has consistently enacted cutting-edge provisions and updates. The bill before you today also updates our law and is a result of the collaborative work with the Legislative Committee of the Probate and Trust section of the Nevada State Bar. Assembly Bill 318 primarily amends Title 12, Wills and Estates of a Deceased Person, and Title 13, Guardianship, Conservatorship, and Trusts. This bill intends to clarify laws relating to trusts and estates, adopt new laws to remain current as one of the top 3 leading jurisdictions for trusts and estates in the United States, streamline the probate and trust administration process while including safeguards to prevent abuse, and provide additional laws in response to the COVID-19 pandemic with respect to electronic wills and trusts and the remote execution of such documents. At this time, Madam Chair, with your permission, I would like to hand over the presentation to Christina Kleist.
Thank you, Assemblywoman. Good afternoon, Chair Scheibel and members of the committee. For the record, I'm Christina Kleist from Brownstein Hyatt Farber-Schreck, here today representing the Probate and Trust section of the State Bar of Nevada. Before I turn it over to Mr. Noble and Mr. Freer to walk you through the bill, I wanted to provide you with a little bit of background on the process of the Legislative Committee of the Probate and Trust section. The committee works internally to develop the proposed language based on case law changes and other necessary updates. Once the Probate and Trust section has vetted the proposed language, it is then circulated to the other sections of the State Bar for their review and comment on potential impacts to other areas of the law. Once each section has vetted the language, it is then sent to the State Bar Board of Governors for their approval to be submitted as a State Bar Probate and Trust section bill. The language submitted by the section to LCB for this bill had no objections by the other sections and was unanimously approved by the Board of Governors to be submitted by the section. The importance of sharing this process with you today is to highlight the level of vetting that the language before you today has gone through. Because of the updates the section proposes each session, Nevada is one of the top 3 jurisdictions in the United States in the area of trust and estate law. And in the past several years, Nevada has also taken on an international prominence as a desirable jurisdiction for establishing and administering trusts. With that, I will turn the presentation over to Mr. Noble to walk you through the first part of the bill.
And first of all, I want to apologize to Assemblywoman Marzola and to Christine Kleist, who did a great job presenting the overall structure of the bill. I'm going to briefly go through a few sections, but I don't want to laborious go through all the sections of the bill. And the sections 1 and 2 of the bill provide for declaratory relief for parties to a power of attorney. Section 3 of the bill is a exemption for fiduciaries who take temporary possession of real property for making real property disclosures. Sections 4 through 16 and 34 relate to electronic wills and simplify and clarify the electronic will statutes, provide for remote execution of trust and wills, and provide a clear procedure where a electronic will can be made into a certified paper copy. Section 15 of the bill was a specific request by the Clark County Public Administrator to enable its office to verify facts when potential abuse is suspected. And Section 16 of the bill provides essentially a privacy for individuals who are attorneys or accountants serving as a fiduciary, that they could use their business address rather than their residential address. Section 820 of the bill provides that a disinterested co-fiduciary can serve, and sections 21 and 26 amend the administrative power provisions to streamline and update Nevada law to when a personal representative may act on behalf of a business, which obviously is happening more and more frequently. And with the different types of business entities, our laws haven't addressed it in quite some time. I'm going to turn the rest of this time over to Alan Freer, the co-chair of the Legislative Committee of the Probate and Trust section.
Thank you, Mark. Alan Freer for the record. Thank you, Madam Chair and members of the committee. In line with the objectives of the bill addressed by Assemblywoman Marzola, I'll briefly address the latter half of the bill. With respect to the concept of streamlined administration, the streamlining continues to be a mandate for the probate and trust section as it seeks to follow the mandate provided by this legislature in 132.010 to ensure a speedy and efficient administration of estates with the least cost to the parties. In line with that, Section 27 permits the court discretion to set aside an estate from a probate proceeding where a pour-over will situation has occurred, thereby reducing the costs to the parties to administer the estate. Likewise, as changes in sections 40, set forth in sections 40 and 41 of the bill regarding notice to creditors and trust proceedings bring procedure in line with the state proceedings, thereby eliminating confusion and the dichotomy between an estate and trust proceeding. With respect to clarifications, and in line with clarifications relating to the laws of trust and estates, the committee did clarify a number of statutes, and I would like to take a moment to build on Assemblywoman Marzola's comments. With Nevada being a national top 3 jurisdiction, it does become a topic of national discussion among practitioners in the area. Due to that, many times areas that are needing potential clarifications are brought to light from those national discussions regarding Nevada law. So in this session, we have sections 28 and 29 clarifying statutory fees and circumstances when an attorney is an independent attorney for the statutory presumption of undue influence. Additionally, an example of this clarification process appears in section 30, which amends the nomination of guardianship statutes. Currently, there are multiple laws that permit the nomination of a guardian in various documents, but the guardianship statutes don't reference these various ways of nominating a guardian. This amendment recognizes all of the current statutory methods of nomination and harmonizes those to avoid potential conflicts of interest among the statutes. Lastly, in this area, Section 42 clarifies circumstances when a divorced parent may represent a minor child by authorizing that the custodial parent or a parent of joint custody has that status. With respect to tax law changes, Section 31 proposes a new statute to statutory amendment to NRS 163, and it is based on an IRS revenue ruling that permitted trusts to include a power by the trustee to reimburse the settlor for tax payments without triggering any onerous tax liability, federal tax liability provisions. And so this statute incorporates that power consistent with the IRS ruling. Lastly, with respect to streamlining administration and protections, there also needs to be protections, as Assemblywoman Marzola addressed. Section 35 is one example for that protection. For beneficiaries, it requires a court order to divide or combine a trust if such power was not expressly granted by the original settlor of the trust. And likewise, Mr. Noble did mention that we had worked with the public administrator, Clark County Public Administrator, regarding some concerns he's seen in his practice. In that regard, we've included an additional group of amendments drafted in conjunction with the Clark County Public Administrator, Rob Tellis, to curb potential abuse. Examples of those occur in sections 44 through 46, and they likewise afford various notice, standing, and informational amendments to permit the Clark County Public, or to permit county public administrators to protect estates, especially in instances where there's an intestate estate that is being administered by a non-spouse, non-heir, or non-next of kin. Lastly, I would just make one point of the Section 47, which is applicable dates. There is retroactivity provision with respect to Section 4, which is the electronic wills and trusts. And as you will recall, when the pandemic hit, a lot of things changed, and the execution of wills and trusts were one of the changes that occurred. Section 47 retroactively applies the changes in Section 4, or the clarification in Section 4, to ensure that wills and trusts that were executed electronically during the pandemic, in conformity with what's occurring in Sections 4 through 16, will also have the same force and effect as if they were executed after the normal October 1 effective date. With that, I'm happy to answer any questions that the committee may have.
All right, thank you. And I think that's all of our presenters, so we will head into questions. Any questions from members of the committee? I see Senator Pickard. Go ahead.
Thank you, Madam Chair. And if y'all listened to the last presentation, you'll understand where I'm coming from. It's when things go sideways with families that I get involved. Outside of a death, of course, that would probably qualify as going sideways as well, but I don't deal with this part of family law. My concern is this, as we look at things like Section 4, where we're talking about audio video, I assume we're talking about a true full audio visual, not the colloquial term meaning either or. So we can't set these things up over telephone, but we can by means of video. And it's when we're looking at, I'm looking right now at Section 9 and how we're converting or revoking these things. Once we've converted it, and this will get into Section 14 and then Section 34, where custodians are converting a trust instead of the will, which is in Section 14, to a certified paper original. My concern is, how do we make sure that this doesn't come from someone who has motive to maybe change the terms a little bit to their favor. How is it that we can revoke something? You know, theoretically, I know blockchain, supposedly you can't, if one node makes a change, the rest don't see it. It's not accepted. How do we make sure someone can revoke an electronic version? Because one of the hallmarks, of course, is their ability to revoke at will. And so unlike a paper copy, they can't tear it up. And then once it's been converted to a certain certified paper original, how do we assure that, for example, in Section 14, the person that's trying to maybe cheat hasn't created that certified paper original for the purposes of circumventing the settlor's intentions?
Thank you, Senator Pickard. I'll address the two questions you asked. First, with respect to revocation of the document, if you look at subsection 9, subsection 2 provides for the three ways that an electronic will can be revoked. First, either by executing a new will, be it electronic or paper, that revokes prior wills. Second, by having it printed out as a certified copy and then doing the physical revocation, similar as you would do with an everyday printed will. Or third, there is a method to do an electronic revocation whereby you contact the qualified custodian and direct that the revocation occur. Moreover, you do have subsection 3 of section 9 and this is existing law that also allows any other revocation implied by law can go ahead and revoke those. So that answers the revocation. I think the more important question you asked, though, is how do we prevent fraud with respect to electronic wills and trusts? And I'm going to try to share my screen real quick. So if I get this wrong, I do apologize. But if you look on the shared screen, you should see two examples of a doc verify document. And this first one on the left is an electronic will and testament. And you'll see the barcodes and the Q codes down here. This is how electronic wills and trusts are held and identified. So you cannot go in and change those while they're in the electronic format. You'll see that each page has the barcodes down at the bottom and source code information down in the bottom left-hand corner. And that's the same. So this first document is a will that my office has done, electronic will. The second document is an electronic trust that Mr. Noble's office at McDonald Carano has done. And it is similar. It also has the same barcodes. And you'll see down at the bottom the same trust signatures or trust codes. And when these are converted to a certified paper original, they will continue to bear those electronic codes. So that's the first avenue to prevent fraud with respect to the electronic wills and trusts. The second avenue would be found in section 12 of the bill, and its existing law under NRS 133-320. And a qualified custodian cannot be an heir, beneficiary, or devotee of an electronic will. And so if it's similar to the requirements of having a witness to a will that cannot be an heir, beneficiary of the will either. It's the same concept for the qualified custodian. Is the person that is going to be tasked with holding the electronic document. It has to be truly disinterested at the time they do keep and present the electronic will. And I will turn, Mark, I don't know if you have any other comments.
I would just like to add that as far as revocation, it's the same as with a written will with the wet signature. Destruction, you can do another will electronically or hard copy. So it's the same circumstances with the electronic versus the paper copy.
All right, thank you. That gives me some peace of mind, I suppose. And then in terms of qualifications of the qualified custodian, that hasn't significantly changed, I assume. I don't see any changes to the qualifications, but that custodian is all important, so I want to make sure I understand that. Have we changed that anywhere?
Alan, for the record, no, that hasn't changed in the probate statutes. In practice, you will discover that most qualified custodians are law firms, and they're done in connection with electronic notaries that provide additional protections, and electronic notaries are required to maintain additional records in addition to that. But that's the practice. But in terms of this bill, no new changes to the qualified custodian have occurred.
All right, thank you for that. Thank you, Madam Chair.
All right. Not seeing any other questions, we will go to testimony in support of AB 318. There is nobody in the room to give testimony, so we will go to testimony on the phone lines.
Thank you, Chair Scheibel. To testify in support on Assembly Bill 318, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 318, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 332, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hello, this is Robert Tejas. The last name is spelled Telles. I am the Clark County Public Administrator. And thank you, Madam Chair, and the members of the committee. And I'd like to thank Assemblywoman Marzola and the probate and trust section of the State Bar. I obviously, as the Clark County Public Administrator, I am in support of this bill. We have seen serious concerns with certain transactions and cases in the probate court where we see equity that might have gone to family members and others ends up through a process instead being washed away and being done by third parties. While it may not be illegal, it's certainly a concern when we want to make sure that that families are protected. So I'm grateful to everyone who's been involved in this process, and I would appreciate the consideration you give to this bill. Thank you very much.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide support testimony at this time.
All right. There is no one here to give opposition testimony in person, so we will go to the phone, please.
Thank you, Chair. The phone lines are open and working. However, there are no callers at this time.
All right. There are also no testifiers here in the neutral position, so we will go to the phone lines. Is there anybody to testify in neutral on AB 318?
Thanks so much, Chair. The phone lines are still open and working. However, there are no callers at this time.
All right. Thank you so much for your help. That concludes the testimony on AB 318. Do the presenters have any closing comments? Go ahead.
I do. Oh, sorry again.
Go ahead, Mr. Noble.
I just wanted to thank you, Assemblywoman Marzola, for sponsoring this bill, and I respectfully urge the committee to vote yes on AB 318. Thank you for your time.
All right, and I think that concludes our hearing on AB 318. I will now close the hearing, and that takes us to public comment. I don't see anybody present to give public comment, so we will go to the phones.
Thanks so much, Chair Scheibel. We are currently on public comment. If you'd like to provide public comment at this time, please press star 9 now to take your place in the queue. Once again, if you'd like to provide public comment at this time, please press star 9 now to take your place in the queue. And Chair Scheibel, the phone lines are open and working. However, there are no callers at this time.
All right, then that concludes our meeting for today. We will be meeting again tomorrow at the same time, 1 p.m. Until then, we are adjourned.